provincial, and territorial officials are examining best practices to maximize the efficient use of available resources. Federal officials will continue to work with their provincial and territorial counterparts to identify long-term solutions to this very serious problem. Next, telewarrants. Currently, telewarrant procedure is available only for certain warrants, authorizations, or orders in respect of search or seizure. Furthermore, the Criminal Code provides that telewarrants are only available where it would be impracticable for the police officer to appear personally before a justice of the peace to make the application, or a justice of the peace. Given advantages in technology and the trend over the past several years to introduce more technology into the justice system to allow, for example, remote appearances and the electronic filing of documents, expanding the number of warrants which can be obtained through the use of telecommunications simply makes good sense, I submit, Mr. Speaker. It contributes to greater efficiency in the use of criminal justice system's limited resources. I would rather see police on the streets patrolling and working on investigations than traveling long distances to make personal applications for a warrant before a justice or justice of the peace. Included in the list of the warrants we propose to make available through telewarrants are trafficking warrants, number recorders, as well as production orders for documents and for financial records. In order to streamline the telewarrant process and to make it even more efficient, we are also proposing to remove the requirement that the officer demonstrate why appearing in person would be impracticable in situations where the telewarrant request produces a, quote, writing, unquote. The impracticable requirement will remain where the request is made orally by the police officer. Next, access to telewarrants by public officers. Mr. Speaker, through this legislation we are proposing that provisions of the Criminal Code that authorize the obtaining of warrants by telecommunications be amended to include public officers in addition to peace officers. The police, who are by definition also peace officers, are solely responsible for the enforcement of the Criminal Code of the Controlled Drugs and Substances Act. While they may also enforce other federal legislation, the primary responsibility for the enforcement of non-criminal offences is typically given to individuals who are not police officers, but who are designated under individual statutes either as peace officers or sometimes as public officers. While the powers that can be exercised by these officers are limited to the context of the legislation under which they are appointed, the powers themselves are typically derived from the Criminal Code. The most commonly used power in this context is the search warrant under Section 487. Pursuant to this section, Mr. Speaker, a warrant may be obtained by either a peace officer or a public officer whose duties include the enforcement of any act of this Parliament. Even though both peace officers and public officers enforcing legislation other than the Criminal Code may obtain warrants pursuant to Section 487, the ability to obtain such a warrant by means of telecommunications is limited only to peace officers. As a result, public officers frequently find themselves in the disadvantageous situation in which they require search warrants but are not able to appear before a justice in a timely manner to obtain one. And examples include officers from the Canadian Food and Inspection Agency in remote agricultural areas and officers appointed to enforce the Canada Labour Code conducting investigations in relation to health and safety issues on offshore oil platforms. The abilities of such officers to obtain warrants under Section 487 is the same as their counterparts who are designated as peace officers, and their need to obtain them by means of telecommunications in a timely manner is equally compelling, Mr. Speaker. The proposed amendment will not in any way expand the powers that may be exercised by public officers, but rather will give them access to the same means for obtaining authorizations for the exercise of those existing powers as is available to other officers able to exercise those same powers. It is in the interest of all Canadians, Mr. Speaker, to facilitate the efficient and effective enforcement of our laws by the people that we empower to do so. Next, identification of the Criminals Act, fingerprinting, photographing, and other measurements. Mr. Speaker, Bill C31, when passed, will provide an amendment to allow the taking of fingerprints and to conduct other identification processes with respect to a person arrested for a serious offence as specified in the Identification of Criminals Act, where that person is subsequently kept in lawful detention. Currently, the Act provides that these powers may be exercised where the person is in lawful custody and is charged with or convicted of an indictable offense listed in the Act. A number of conditions must be met for the proposed amendment to come into play. Firstly, the arrest, as any other, must be based on reasonable grounds to believe that the person committed or is about to commit an indictable offense. Secondly, the police officer must believe on reasonable grounds that it is necessary and in the public interest that the person be detained in custody until brought to appear before a justice. Only in these limited circumstances will police be permitted to proceed with the identification process without having to wait for the formal laying of the charge. In most situations, the proposed amendments will only affect the point in time where the identification processes are performed. Mr. Speaker, if the person is ultimately not charged with an offense, or charges are withdrawn as a result of an acquittal, police services will usually destroy fingerprints and photographs of the person's request. It is important to note that the courts have stated that it is not unreasonable for the police to retain prints where no request is made for their destruction or for their return. The proposed changes to the Identification of Criminals Act, Mr. Speaker, will result in streamlining the identification process and avoid having to detain the person for an extended period of time while waiting for the actual charge to be laid before proceeding with the much-needed identification processes. Corruption of foreign public officials and bribery. Finally, Mr. Speaker, in support of Canada's international obligations, this bill contains amendments to the Corruption of Foreign Public Officials Act, the Criminal Code, and the Canada Evidence Act. One of the amendments gives nationality jurisdictions to Canada for offences of foreign bribery. Most of the time, these offences are committed in a foreign country. Currently, Canada exercises territorial jurisdiction. This allows Canada to prosecute an offence committed in a foreign country when there is a, quote, real and substantial link, unquote, between the offence committed in the foreign country and the country of Canada. Nationality jurisdiction will allow Canada to prosecute offences of foreign bribery committed outside Canada by Canadians, permanent residents of Canada, and Canadian corporations without having to provide evidence of a link between Canada and the offence. This will facilitate prosecutions of foreign bribery cases, Mr. Speaker. In addition, we propose to add the word selected to the definition of the word official in Section 118 of the Criminal Code, which applies to corruption provisions. Currently, Mr. Speaker, this regime applies only to persons appointed or elected. The Federal Accountability Act provides that the appointed process for some members of public service include consultations with Parliament. Under this process, the name of a person, quote, selected, unquote, for an office is made public before the person is actually appointed. But the person is not an official under the current definition and therefore is not subject to the bribery provisions until the legal appointment. In addition, Mr. Speaker, the Organization of American States, or the OAS, and the Inter-American Convention Against Bribery that Canada ratified in 2001 requires the criminalization of bribery to officials, quote, who have been selected, appointed, or elected, unquote. So, Mr. Speaker, the proposed amendments will correct this gap in the current law. Other amendments. This bill contains many other amendments, such as those that will update the outdated prize fighting and parimutuel betting as recommended through consultations with our federal, provincial, and territorial stakeholders and other levels of government. So, Mr. Speaker, I trust that all members will give this bill support that it requires. These amendments will contribute to the significant improvements in efficiency and effectiveness of the criminal justice system that all Canadians are asking for. Criminals are evolving and becoming more complicated and more sophisticated. The law must evolve to keep up. Thank you, Mr. Speaker.